I showed y'all where Brent Wheeler forwarded to me the ballistics memorandum July 24th, 2002. And so what I did after I discovered these information and saw just how much evidence had been withheld, we hired a private investigator, retired ABI agent, Mr. Gary Fox, to work with us. And I'll admit, when I hired Mr. Fox, I already had possession of the ballistics memorandum, but I didn't tell him about it because I really wanted to see, how thorough he would investigate. And I also wanted to see what the state would tell him as he began to ask questions about my case. And so I'm going to show you something. I'm going to put these two documents beside each other. There's Brent Wheeler's name, and here is page 2. This is page 1 of Mr. Fox's report, and this is page 2. And he says, he said, I talked to Brent Wheeler, the head of Alabama Department of Forensic Science. He said that he wasn't able to talk about specifics of the case, but that he did not believe there were any ballistic tests done on the projectile removed in the second autopsy due to the fact that there was no weapon found to do comparison on. He also said that the Madison County District Attorney never requested any test, and with money as tight as it was and is, the test was not conducted without their request. He could not remember the caliber of projectile. I told him that the autopsy did not reveal the caliber, only diameter. He said the best he could remember, it could have possibly been a 9mm or a 380. He really didn't know. Okay, but here it is. He's telling me he sent me he actually sent me the report. And now for the first time, you hear the word 380. So you can see that they were lying and that these lies went, all the way to the top. How is it that he can't remember? How could he possibly guess on the caliber of the weapon? He said that the test would not be conducted without their request. The test would not be conducted. He could not remember the caliber of the projectile. So, it's one lie after another about this projectile. And we had the records to show that they didn't disclose it to us prior to trial. As many of you all know, Anthony Ray Hinton, a man who spent almost 30 years on death row, was just released from death row for the exact same thing. The prosecutors manipulating the ballistics evidence in the trial to falsely convict. And so we're on it, They did it in our case. We got the documents. We can prove it. We got the testimony. And so we're going to put this out there, and we're going to continue to fight this fight until we get the justice that we are entitled to. I'm going to close with something. This is a document, audit report of the Alabama Department of Forensic Science Laboratories. And you can see here that even the forensics people are frauds. The accreditation agency is a fraud. Note that the findings and observations in this report are for pre-decisional purposes only. An escape clause to get you off the hook in case the report is discovered and there are questions about non-implementation. Someone wrote why. Why did they put that on there? And so I went through this document earlier today, and some of the things I saw, just make you scratch your head. The toxicology section does not have a description of evidence packaging in medical examiner cases. Interviews reveal that items are received in heat-sealed bags, but there is no documentation of this in the case record to ensure that the integrity of the evidence is maintained. let's see, what else we got here. One case from the forensic biology section was reviewed and the analyst, without using the laboratory established, what that means, match criteria, called an off-ladder ally. The call was made based on a visual assessment of the jail image. This call cannot be supported without supporting silent data. Given the laboratory does not retain computer data, this call cannot be verified. It should be noted that this sample was not rerun. Who knows what the result of that is? Who knows if someone's um, um, been falsely convicted based on that? So many different things. It said, numerous items were found in the firearms section that were sealed, but the seal was not initial. Items in the controlled substance section were placed in a plastic bag and sealed with tape that could readily be pulled from the plastic without detection. There were uninitial seals on evidence in the controlled substance section. These are original seals, not initial by the sealing officer. More. Let's see. What else I found in this report? The toxicology section and medical lab has areas of their laboratory which are shared with the hospital and their hospital staff. These two areas do not have controlled and limited access, since hospital staff can readily access them. The shared space allow for entry/exit to the laboratory. The laboratory quality manual states that non-employees will be given a visitor's pass to display by the laboratory. This is not being followed, so that means anyone is roaming around. It says areas of the toxicology section are not secure during vacant hours because they are shared with the hospital. Now, check this out. It says several members of the staff that were interviewed voiced displeasure with the audit process and the move toward accreditation. One individual felt that each audit just made things worse for her program. Don't even want to be audited. Let's see. The forensic biology section has not validated the use of the 13 core codis loci required for participation in the National DNA Database. The laboratory should aggressively pursue the validation. So we have a forensic science laboratory performing dirty work. We have Brent Wheeler lying to my private investigator about a report that he had already turned over to me. And so we're going to continue to expose this miscarriage of justice and get to the bottom of this case, and find out why there are so many lies, why we don't know who provided this gunshot information, why we were not informed about the 380. What did the person who come forward about the gunshot information say? Did they say anything about this 380? Did they admit to any culpability or involvement in the crime? Because after trial, this is what I found out. And I'm going to close with this. This is a motion to seal that was filed by my attorney. And it was filed February 28, 2001, Arthur Davis. And this is what he found out. He said, on February 25th, the undersigned counsel and his investigator came into possession of information that suggested at least one and possibly two individuals who have not been charged were also involved in the killing of Andre Horton. On February 27th, in an off-the-record proffer, counsel disclosed to the chief prosecutor in this case the identity of these individuals. The prosecution has expressed an interest in conducting additional investigation in an effort to corroborate the information provided. And so what that is saying is there are some more people that have knowledge about this, and it is possible that one of them stepped forward and told the investigators about this gunshot and probably about this 380, and no telling what else. But the prosecutor is refusing to disclose the identity of this people, refusing to disclose the statement. As you all saw, he had already refused to disclose the ballistics information in this case. And we don't know what else has been withheld. We have no way of knowing. But we're going to try to find out. And so I hope you take interest in this cause. We'll continue to expose more information about this case. You'll be able to view it on our website and our blog. And we're not going to stop until justice is rendered and this miscarriage of justice is corrected. And I'm returned back to my family and I get my freedom.